This Honorable Court of Appeals of Tennessee is now in session.
Thank you, Mr. Hivner. On behalf of Judge Bennett and Judge McBrayer, we're pleased to welcome counsel who are participating in this hearing, which is being live streamed for the benefit of the public. We will conduct the hearing in the same fashion as if we were all in the courtroom together, and each side has 15 minutes, and the appellant has already reserved some of that for rebuttal. Unless there are any announcements, I'll ask Mr. Hivner to call the case.
In Re Ashlynn H.
You have the floor.
Your Honor, I'm Peter Trinke of the Winchester Bar, and I represent the father, Mr. Taylor J. And the trial court has erred in finding that he has willfully abandoned this child, and they've erred in finding that he has not manifested a willingness and an ability to care for the child. The underlying facts of this case is that when the mother became pregnant, she...
Now, is it your position those are the only two grounds for termination relied on by the trial court?
That is my position. Any other grounds, I'm going to say they erred on those because of...
Well, I mean, it's either yes, the trial court relied on only two grounds for termination, or no, there's more. I'm having a hard time figuring out from the trial court's order what grounds precisely, because the code section cited is a miscite. It's a typo of some sort. So is your position that the trial court only relied on two grounds, yes or no?
Well, my position is I had the same misunderstanding, and those are the grounds I could construe from the order. That my position would be they erred in finding grounds to terminate, and so the grounds that appeared to be the ones found by the trial court are the grounds that I argued against in order to focus the argument.
Okay, that's my question. You're appealing the two grounds that you feel like the court relied on, and there's no other grounds. You didn't intend to admit any ground that the court relied on.
No, Your Honor. We're admitting no grounds, and also we're contesting the finding that it's in the best interest of this child. And the background history of this case is one that when the mother found out she was pregnant, she arranged for an adoption with the petitioners and thwarted the father's efforts to support her or to see the child. And so you cannot find willfulness when he made efforts. And I will freely admit he didn't have the highest capacity of any individual I have known, but within his capacity, he made efforts to support the mother when she was pregnant. He made efforts to visit with the child. He arguably made efforts to support the child. And you also have a finding about the 4 months prior to the filing of the petition. The petition was filed when this child was approximately 6 weeks old. So you can't even find that 4-month time period. So the abandonment, as it's found in terms of willful failure to visit or willful failure to make payments, his actions were not willful. And I rely upon his testimony, and it's not controverted by anybody else's testimony as to his willfulness. There is some testimony regarding a disagreement about his efforts to contact the child, but the way this played out is he tried to contact the mother because he didn't know who the potential adoptive parents were, and he did not get that information until very late in the game. So that's the basic position. And to have a finding he abandoned because of wanton disregard, his criminal record is based only on 2 assault charges, and these happened prior to the birth of the child.
So he had 2 assault charges. What were the dates of those convictions?
But Your Honor, I don't have that information before me. However, the behavior,
Well, I mean, you
legal
said it happened before the birth of the child. Isn't it important to know the timing on that? Can you give me years?
Your Honor, again, I don't have the evidentiary record in front of me to be able to look that up.
Let's put it another way. Was it within 9 months of the child's, were they within 9 months of the child's birth? Did these assaults occur when he knew he was going to be a father?
Well, I'm unable even to recite those facts.
Well, you need to know these things when you come up here to the appellate court.
Well, I do not disagree, but I don't have that reference in front of me. And his only subsequent incarceration was for violation of probation, which was not an additional criminal act. And the finding about his work history is based strictly on the mother's testimony. He testified that at the time of the hearing, he had employment. And he also, in terms of finding that of him manifesting an ability to care for the child, he never was given an opportunity to demonstrate his ability or lack of ability to care for the child. And in terms of best interest findings, there was no evidence that he was ever any kind of physical risk to this child. And of course, we have no evidence of his interaction with the child because those efforts were thwarted. And that would be the basis of my argument.
Well, let me ask you, the petition for to terminate the father's rights was filed something like 6 weeks after the child's birth, right?
That is correct.
And yet most of the statutes on terminating rights talk about looking at the period of 40 days before the filing of the petition. So how do we mesh that together? Or do you have to wait till 41 days after the child was born to file a petition?
That would be my position is they could have and they should have waited. If you want to use that measure of the 4 months prior to the filing of the petition, then the argument would be that child was not a life and being during that entire time, and so that measure it's inappropriate to apply it.
So you think if you're going to use one of those circumstances, you have to wait at least 4 months and a day after the child is born to.
That would be my argument. Otherwise, it is an inaccurate measure because you don't have that full time period to examine.
Okay, thank you.
Thank you, and I will cede the rest of my time to Mr. Ford, or we can cancel the clock because my argument is just very basic and relatively brief.
Thank you, Mr. Trinke. We'll now hear from Mr. Ford. Be sure to unmute.
Can you hear me now?
Yes, sir.
Thank you. Regarding the willful abandonment, there is a statute that indicates that this man was supposed to, in order to prove abandonment, he failed to provide support to the minor child's mother during her pregnancy, commensurate with his ability. The testimony was that he knew this woman was with child 3 weeks after she became pregnant. He testified that he approached her one time to see if she needed money and claimed that she said that she had a boyfriend who was taking care of everything. Contrary to that, she testified that they did talk about him providing support. She said she would take it, need it if he would do it, and he never did. He also testified that he had money at the time, had the ability to pay, was providing his own necessities, but never sent her anything. The trial judge accepted the credibility of the mother and did not
So
find the father's testimony to
how
be
many grounds did the trial court rely on for terminating this father's parental rights? How many statutory grounds are we dealing with here?
I think it's more than just the two. It has to
So
do with
can you give me the statutory cites to the more than two that the court has relied on here?
well, the citation in the order I think Your Honor's indicated was wrong. 36-1102 A13.
You disagree with that? Is it correct?
Your Honor, I don't have the statute in front of me. I will obviously defer to you if that number is wrong. But there, it alleged and found that he.
Well, let me start then with something you should know. What grounds did you seek termination of parental rights on?
Abandonment, manifest unwillingness and ability to care
Under
for the child.
113 G1, right?
Yes, Your Honor.
Okay, so what's the other one that you sought it under? G what?
Risk of substantial harm to the child to go with
Which
the
is
father.
G what? Tell me which number.
Your Honor, I don't have the book in front of me and I don't have them memorized. I apologize profusely. I can't say. I know. I assume
Well, give me the number of grounds that you sought termination of parental rights on. Are we talking about 4, 5? It's all in a single paragraph in your petition. I can't make any sense about how many grounds you are seeking termination on.
I tried to list at least 4, Your Honor.
So there's at least 4, but we don't know the precise number.
I didn't put the statutory citations in the petition.
So do we have a serious notice problem here since you can't tell and I can't tell what the grounds are that you're seeking termination of parental rights on?
Your Honor, I think that by giving the appellant notice that we were seeking to terminate on these 2 grounds, willful abandonment and the manifest willingness and ability to care for the child, that was sufficient. Those 2 in and of themselves would be sufficient. I think he had proper notice, and Mr. Trinke filed a response to the petition, never raised the issue.
But under the Supreme Court case law, we have got to look at all the grounds that the court relies on. Tell me which grounds. I mean, what ground has the court relied on here?
Abandonment and
just the 2.
I think so. Yes, Your Honor.
So we're only worried about those 2 that you just mentioned, abandonment. And what's your position under what definition of abandonment are we going under here?
Failure to provide support to the mother during her pregnancy.
So you're saying it's 1A Romanet 3.
Yes, Your Honor.
And no others.
With regard to abandonment?
Yes.
Because of the 4-month time period now, I think we can show that he didn't visit with the child or provide support for the child.
Well, what I'm concerned about here is what the trial court relied on in terminating this gentleman's parental rights.
I think it had to do with his failure to provide support to the mother during her pregnancy, commensurate with his ability to do so.
Okay, and you say that's 1A Romanet 3.
Yes, Your Honor.
Okay, and is there any other definition of abandonment you think the trial court relied on here? Because she mentions wanton disregard. That's under a totally different definition. So I want to make sure that we're completely clear on what grounds we're reviewing.
She did, in fact, find a wanton disregard for the welfare of the child, which is separate, but I sort of took that to be under the abandonment, the general abandonment of the child.
Okay, so still under Romanet 3.
Yes, Your Honor. Now, with regard to, I've already told you about the abandonment for failure to support. with regard to the not manifesting a willingness to an ability to pay or to care for the child, there were repeated incarcerations, and those occurred immediately prior to the trial of the case. As a matter of fact, the young man was in jail when he was served, and he got out of jail 3 weeks before the trial of the case. He was in jail 5 to 6 times during 2019, as found by the court, and I think the proof would certainly sustain that. There's a history of violence this young man has shown, even toward the mother. He admitted threatening the mother. At a time, he says he was trying to see the child, and he had beaten up some fella in the jail and indicated that the mother should take his threats seriously. There was a history of drug and methamphetamine use by the appellant. According to the mother, she had seen him about a month prior to the trial. He appeared to be
Did
under
the trial court make a finding about methamphetamine use? And
yes,
if so, where was that in the order?
I think it's in the transcript, Your Honor.
Okay, I'm looking at now. Give me the page of that, please.
Does the trial court have to make written findings of fact, and therefore the transcript of the evidence wouldn't be sufficient?
Well, it's a transcript of her findings, Your Honor. She made an oral decision that was transcribed and attached to the written order. And I'm trying to find where she spoke about the drug use.
There's a reference to it on, I guess it's the second page of the transcript. Maybe it's labeled page 3. During these periods of time, apparently up in his latest 4 months ago, he was using illegal drugs.
Yes.
That's the only thing I found.
Yes, and that was according to his testimony, Your Honor. The mother said that she had seen him under the influence about a month prior to the trial. There's a history of his failure to have a job, and he actually admitted that. It wasn't just testified to by the mother. At the time of the trial, he claimed to have been working for 2 weeks, but brought no proof of that, and indicated he had drawn disability in the past and lost it because he went to prison. And he was back working, but still trying to get on disability, even though he was working. He also testified he had no home of his own. He had lived with his grandmother and other family members. He was living with a Miss Luttrell at the time of the hearing, had been there for 2 weeks, was not on the lease, and could not even give the address of where he was living. He had no vehicle, no transportation, did not have the ability to take the child to the doctor if sick. He had absolutely no plan of care for the child, other than to say, I'm the father and I'll work and take care of the child. He couldn't say where the child would live, if he could get insurance on the child, nothing. Last I understood,
Did the father's name appear on the birth certificate?
not to my knowledge, Your Honor. I don't think anybody was listed on the certificate, but the testimony all was that he is the father, and I don't think there's an issue in that regard. Last I heard, frankly, this young man's whereabouts are unknown and have been since the trial. Regarding the best interests of the child to have this adoption go through and the termination occur, the mother stipulated she was incapable of caring for the child. I think the proof was unequivocal, and by clear and convincing evidence that the father is unable to care for the child. He abandoned the child upon learning of the pregnancy, didn't provide any support, and he can barely take care of himself. He has no ability to care for this child. There was an argument by Mr. Trinke that his attempt to visit was thwarted by the adoptive parents and the mother. That's not what the testimony was, is that there were appointments scheduled and not kept by the appellant to see the child. The proof showed that this child was thriving and is thriving in the care of the prospective adoptive parents. And they both testified that this child is their life, took care of the child perfectly, and had the ability to do so, both working, providing support to the child. And it's, I submit to your honors that it showed by clear and convincing evidence that's in the best interest of this child for the termination to occur and for the adoption to go through. I'm asking the court to sustain the judge's decision in that regard.
All right, hearing no further questions, we'll hear Mr. Trinke's rebuttal.
May it please the court, I would first address the answer to the petition where all the grounds are stated in paragraph 18. The answer to that paragraph is a single word: deny. So the appellant at that point did not delve into any questions about the grounds, but merely denied all of the grounds as stated in the petition. And the issue of whether he failed to support the mother when she was pregnant would be a matter of looking at the testimony and deciding the truthfulness of the father's testimony versus the mother's testimony. And the same holds true on the alleged appointments that were made for him to visit, as to whether the court were to find him credible or to find the other witnesses credible. And in the eyes of the court, he did not present well. And this is a situation where these individuals conspired with the mother to take this child. They conspired before birth. They took this child at birth, and they moved immediately to a termination petition without giving the father any fair opportunity to be a father at any level of involvement. And it's difficult to find that that's in the best interest of this child, who's never even had an opportunity to know their father, and never even was presented an opportunity to determine on their own what their relationship with the father ought to be. And so it fails on the best interest test, because basically they hijacked this child using a power of attorney and then a termination petition. And they thwarted his efforts, which may not have been as much as one would hope, but he was making efforts and they were thwarted, and he didn't have perhaps the capacity to know what to do next. And so that's
but it sounds like you're making a willfulness argument here, that your client's behavior or activities weren't willful in terms of visiting and supporting the mother, but you didn't raise that as an affirmative defense.
Well, and I don't have a good response to that, because I do believe they were not willful. And a lot of that came out during the testimony rather than during trial preparation. And that would be my counter argument. Thank you.
Thank you, Mr. Trinke and Mr. Ford, for your arguments. We will take this matter under advisement. Mr. Hibner.
This honorable court is now in recess until 1 p.m.